This is a capital gain deferral technique. It doesn't eliminate capital gains, but it spreads it over that 20-year period, the length of the note.
Powerful tools to defer taxes and on the grantor trust to get more assets into a green box without using exemption.
Trevor, good to have you here with us again. As everybody knows, I'm the managing partner of Dana Whiting Law. You've been my partner for a long time. You've been with the firm for 15 years. First job you had coming out of law school. I really appreciate you hanging with us and building this firm together.
It's a good run so far.
We have both of our names on the building out there, and we don't know how the story's going to end, but it's going to end very well.
That's right.
We're talking about installment sales, and usually on our other videos, we talk about the installment sale to a grantor trust, and we use that as a classic freeze technique. And, we talked about an installment sale to a grantor trust. The sale in and of itself doesn't trigger any capital gains at all. So, Trevor, talking about installment sales to a non-grantor trust, walk us through how that's different than selling to a grantor trust.
Yeah, on the sale to a grantor trust, it's a estate tax strategy.
Yeah.
Right. We're trying to get more assets into a green box so that we save on estate taxes, and it has no impact for income tax purposes. There's not a sale. We don't pay tax on the interest that's repaid. So on the non-grantor trust sale, what we're going to do is we're going to sell assets to a non-grantor trust, and we actually are going to trigger capital gains taxes.
Yes.
We still get the estate tax benefit in that the assets end up in a green box that's exempt from estate taxes. But we trigger capital gains tax, but what we're doing is we're getting that capital gain spread out over the lifetime of the promissory note.
Yes.
So when you sell on an installment basis to a non-grantor trust, and that installment note's scheduled for 15 or 20 years, then you only pay capital gains tax on a piece of the payment that comes back to the seller every year.
Yeah.
And it's spread out. So now you don't have this huge tax liability up front like you might have if you were going to sell your business to a third party that was going to pay you all cash for your business.
This is a capital gain deferral technique. It doesn't eliminate capital gains, but it spreads it over that 20-year period, the length of the note. And Trevor, we've talked about, and we've looked at this for some of our clients, the sale before the sale, right? So I believe this is a Code Section 453 transaction. I think 453A has some provisions in it, but essentially, if I know I'm going to sell my business, let's say in 2 years or 3 years, and I know that's probably going to be a cash deal, and I don't want to pay that huge capital gain on that cash deal. If I have this first sale where I sell it to a friendly party, a related party, a SLAT that I created for Nancy, and I sell it to there, and I make that SLAT a non-grantor trust, and generally we make those grantor, but this one would be a non-grantor. And so now I'm going to recognize capital gain on that piece that trust is paying back to me over the next 20 years. Now, I think you have to wait 2 years, and then Nancy, out of that SLAT, she can sell that thing for cash, right? When she bought it, let's say she bought it for $25 million, she has basis now of $25 million. And so if she turns around and sells it, let's say 2 years later for $30 million cash, the trust, the SLAT only has to pay capital gains on that $5 million, correct?
That's right.
The other $25 million, how's that going to be taxed?
That's going to be taxed as those payments are being made from that trust back to you that did the initial sale, right? The first sale into that trust, we stretch it out over the 15 or 20 years. The $25 million of capital gains, if your basis was zero and you sold for $25 million, you're still going to pay tax on that, but we spread it out over that 20-year period, and we get the deferral. And one of the challenging parts, Matt, is we're going to trigger that capital gain before we sell. We're actually selling the business.
We got to pay it early.
So
for
we got
2 years.
For 2 years, we got to pay some capital gains before we actually have that buyer that's putting the cash in. But once we, that second sale, when Nancy sells the second time for $30 million, only having to pay tax on a lump sum of $5 million at that point in time is a huge tax benefit.
Yeah. That's where I know you and I have used this strategy before, is the sale before the sale to get this capital gain deferral. I also use this strategy on this same case that we talked about over on the installment sale to the freeze technique to a grantor trust. We had a husband and wife, and by the time I got involved, the husband had just died, and he hadn't created a SLAT. He had used his exemption. And as you know, we generally have in place when a client dies, and if they haven't used their exemption, you can create a SLAT at death. SLATs can be created during life, or SLATs can be created at death. So when he died, his exemption, we locked it into a SLAT for his wife that he created at death. Wife got a step up in basis before it went over there. Are you hearing me on this? So we actually structured this, doing 2 sales, right? We also created grantor trust for the kids, the decedent's trust, or the non-grantor trust that the husband created. We got a step up in basis on those assets. We sold it over there with no capital gain at all, and then she took back a note. There again, why would she do this? A freeze technique, right? It was on the same business we talked about. So now she's getting a freeze technique, and we don't really care about capital gains because we've got to step up in basis. So sometimes if a client hasn't done this while they're alive, we can certainly still do it after the death of the first spouse.
Or you can, check out our video on the Uncle Murray and provision and stepping up their basis inside of a SLAT.
Yeah.
Anytime we get a step up in basis, then we can consider selling to that non-grantor trust, and start that 2-year period before we do a sale to an unrelated party.
Yeah, think about this, Trevor. We're talking about installment sales. In real estate, people understand what an installment sale is. I can go out and sell my property for $5 million cash. I pay capital gain up front, $5 million. On the other hand, if I sell my real estate $5 million and I take back a note, and that's a 20-year note, I pay the capital gain on those little pieces over 20 years. People understand that. There's not a similar provision that allows you to sell publicly traded stock on the installment basis. You just can't do it, right? But you can do it if you put that publicly traded stock into an LLC first, and then we sell the LLC over to the SLAT, right?
Right.
And we either do it a non-grantor trust or a grantor trust. So I can get the same installment sale treatment on publicly traded stock if I put it in an LLC first.
That's right. You're just controlling the actual asset that's being sold is an interest in that LLC.
Yeah.
As opposed to every individual share of stock that you own that's in the brokerage account in that LLC.
Yeah, would that same 2-year rule apply? I think that the sale before the sale, I would think it would. If I sell it as an installment basis to a green box and I'm taking back that note, that second sale can't happen until 2 years.
That's right. It applies when that first sale is to a related party.
Yeah.
Right. So if you're selling
whatever we're selling,
if it's to a related party, and so a green box, whether it's a grantor trust or a non-grantor trust that we're setting up, that's going to count as a related party because we're setting those up for our spouse or our kids or our grandkids, and so that's where that 2-year rule comes into place.
But Trevor, is there anything else you want to say on installment notes? I think we've covered a lot here in the grantor and non-grantor setting. Very powerful tool.
Powerful tools to defer taxes and on the grantor trust to get more assets into a green box without using exemption.
What I want our viewers to know is we're not a one-trick pony, are we?
No.
State tax, capital gains, exit strategies. Give us a call if you're thinking about selling a business in the next 2 to 3 years, you don't wait till you sell it and come in and brag to us that you sold your business for 30, 40 million. You come in before. We do a lot of this planning has to be done before.
That's right.
All right. Have a good day.
You too, Matt.